summary judgment, and we will start with order 14. Order 14. So it is expected that at the end of this lecture, you will be able to understand the nature and purpose of a summary judgment application. And then the manual also requires that you should be able to explain the conditions for granting the summary judgment. And you should also be able to analyze how a defendant may successfully resist summary judgment. If application is brought for summary judgment against you as a defendant, what can you do to resist it so that the court will not grant it? And again, we should be able to distinguish summary judgment from default judgment and striking out. Because on the surface, they seem to be similar, but they are not. So we need to understand how summary judgment is distinct from, let's say, the judgment in default of defense or judgment in default of appearance, or where a suit has been or pleading has been strike out in person to the 11 Rule 18. Yeah, so that we need to appreciate the difference. And finally, it is required that we should be able to draft the application for summary judgment. So we don't have to only know the rules, but we should also be able to know how to draft it. So conceptually, what is summary judgment? What is summary judgment? But before we do that, as we usually do, we said that it's better to always look at the law. So we are going to read the law quickly, and then we take our time to discuss the breakdown. So order 14, Rule 1, application for summary judgment. Where in an action a defendant has been said the statement of claim and has filed appearance, the plaintiff may, on notice, apply to the court for judgment against the defendant on the ground that the defendant has no defense to a claim included in the writ or to a particular part of such a claim, or that the defendant has no defense to such a claim or part of a claim, except as to the amount of any damages claimed. Good. So, from order 14, Rule 1, thank you. Thank you. A summary judgment, first of all, is a final judgment. It's a final judgment. And when we say final judgment, we are using it in contradistinction to interlocutory judgment. And I hope now you appreciate the difference. Yeah, so a summary judgment is a final judgment entered by the court without the conduct of a full trial. So ordinarily, we are supposed to have like the full trial, where the party who bears the burden of proof will start the case, open his case, the other party will now respond, and then they will address the court. Then the court will come out with judgment. So that is a full trial, the plenary trial. But in a summary judgment, the court is able to use, as it were, a shortcut to reach a judgment without going through the full trial. Where the defendant has no bona fide defense, to the plaintiff's claim as disclosed on the pleadings and also the affidavit evidence. So where the plaintiff can show to the court that based upon the pleading, based upon the statement of claim, based upon information I put in affidavit evidence supporting application, there's no way that the defendant can actually answer this aspect of my claim or the entirety of my claim. So there's no point in we going to wait and go through the motions of trial. Allow me to sign the judgment. So that is a summary judgment. So when we say summary judgment is a final judgment, what it means is that once it is entered, it conclusively determines the rights of the parties on the claim or part of the claim, subject only to appeal or maybe setting aside under the 14 Rule 9. So where there's no setting aside, let's say under the 14 Rule 9, which we'll be discussing, or where there's no appeal, or in the worst case scenario, assuming we have a certiorari on a judicial review. Apart from those instances, the judgment entered as a summary judgment is what? It's final, because it definitively, conclusively settle or determine the rights of the parties as far as the claim is concerned, or the part of the claim in respect of which the summary judgment has been what entered is concerned. So let us keep that in mind. So the essential characteristics of a summary judgment is that there is absence of any triable issue. There's no triable what? Issue, whether of fact or law. So in terms of law, there is nothing contested which needs to be inquired into in the trial. In terms of facts, there is nothing contested which needs to be inquired into during the trial. And that is why we say that an important or essential characteristic of a summary judgment is that we have absence of any triable what? Issue, whether of fact or law. So here, the court does not need to evaluate evidence on contested fact, assess anybody's credibility of their witnesses and so on before to come to a decision. There's nothing like that. So the court will proceed on assumption that even if the defendant's version of the events were accepted at the face value, the defense discloses no answer or no defense recognized by law to the claim which the plaintiff is what? Is making. So that is the essence of Order 18, Order 14. So therefore, Order 14 is a sort of like a fast track, procedural mechanism, a fast track for summary disposal of what? Of claims that do not require a full-fledged hearing. And those of you who have gone to court before, you notice that trial is a bit laborious and cumbersome. It's not just one day. Somebody will open his case, give evidence in chief through the examination in chief. You have to be cross-examined. And cross-examination can take a whole lot of time. After that, there may be some re-examination. Then you call another witness. You go through it. And so you can imagine, there may also be a case that somebody will bring a motion to recall a witness who has already been discharged, and a whole lot of banter. So all those things are quite laborious, but in summary judgment, you avoid all that. So it's a fast track, if you like, procedure for summary disposal of claims that do not require a full-fledged hearing, as it were. And if we look at summary judgment, we can see that it's consistent with the underlying philosophy of the civil procedure rules, Order 1. What does Order 1 says? Remember Order 1, Rule 1, Sub-Rule 2 of CR 47, that the rules should be interpreted and applied in a way that to ensure speedy and effective what? Justice. Speedy and effective what? Justice. Avoid delays and unnecessary expense, and ensure that disputes are completely and effectively what? Resolved. And that is what summary judgment actually says to do. Yes. There's a problem. My intent. Oh, thank you. I think you have my welfare. Yes. I've noticed that. I've noticed that she has my welfare on heart. So if she doesn't get the opportunity to answer a question, I think for her humanitarian, I can give her one. But we'll take a vote if the class agrees. Don't agree. No. But I've remembered, she didn't do the quiz. And some of you didn't do the quiz, she didn't benefit from her wrongdoing. So Yeah, you all know that justice delay what? Yeah, so where delay will serve no substantive purpose. What do you mean by that? If you have to wait and go through the full cycle of trial, and at the end of the day, nothing is going to change, then what is the point of doing that? And that is why summary judgment is very what? It's important in deserving cases. Yes.
Apart from the course coming to the determination of
can give the mic to him.
my Lord, I'm asking, apart from the court
yes,
coming to the determination that the defendant doesn't have the pleading that is disclosed because of action, for which reason the plaintiff is taking summary judgment.
No, that is not it. Because that one we have Order 11 Rule 18A. Order 11 Rule 18 1A. What we are saying that the defense does not disclose any reasonable cause of what? No, any reasonable cause of defense. No. So the defense should be strike out. That one is there. For summary judgment, as you will notice, the plaintiff need not wait for criminal defense to be filed. All that we need to do is the appearance of the word entered. Yes, so but then for Order 11 Rule 18 1A, you need to wait for defense to be what? To be filed. Before you examine it and say that, okay, if I read my statement of claim and I read the same defense, this defense is a sham. It doesn't disclose any reasonable cause of what defense, so it should be strike out. Yes.
So, my Lord, can the plaintiff also take summary judgment on the admissions made by the defense in the statement of defense?
Good. We also have judgment admission, Order 23. I think it's Order 23. You're not reading yourself 47. It's Order 23 or 24. 23. You know, you are fortunate. When I was a student like you in 2001 learning civil procedure, I didn't learn CI 47. It was not like CI 47. CI 47 came in 2004. I had become a lawyer already. I learned LN 140A. So we had to learn, and that is one thing about a lawyer, and you have to note this. A lawyer must always be updating yourself because the laws are being made every now and what? Again. It may well be that by the time you become a lawyer, there may be something. Even as I speak now, the one we met our new boss, the CJ, he hinted that the rules of court committee are working on the let's say the CI 47 and some other things. So assuming they are able to do comprehensive work and make complete overhaul, we may have. Well, you are worried. No. Since that is why it looks. So the whole point about legal education, especially the purpose of those becoming a lawyer, in my view, is about two skills. One, where to find the relevant law. And two, how to interpret and apply the law. These are the two skills which are important. So once you have these two skills, you are ready to go into the legal world. Whatever problem that you have, you know where and how to look for the relevant what? Law. Like if I say relevant law, the law which is relevant to the particular matter that you have. And two, once you're able to locate it, you know what to make sense of it professionally to apply it to whatever scenario that you have, isn't it? So these two skills are important so that if you go to legal education and you haven't acquired this, your legal education is a suspect and it will not take you far. Because the law will not stand still. Law keeps evolving. Even when it comes to decisions of the court, when I was learning civil procedure, the authorities that we were citing, so many of them have come because this 2026, isn't it? 2026 means that by October, I've been a lawyer for 23 years or something. So since leaving the law school, 23 years, a lot of things are evolved. Yes. So assuming you don't know how to update your knowledge, then you'll be in trouble. So don't be worried about the fact that maybe by the time you become a lawyer or when you become a low time, the laws will change. So you're worried that why am I learning this? No, don't worry. Even if the law changes, you'll still be able to work your way around because you know you have the skills. You have the skills. And also some of them will not change fundamentally. There'll be some addition, but the substance remains what? The same. And that is why I said that it's important to understand the principles. Once you know the principles, be able to adapt them as it were. Yeah, so we'll come and discuss judgment and admission. I think that's what the 23. 23, yeah. We have a judgment and admission. We'll come and discuss that also. It's not the same as summary judgment. Because as the name suggests, judgment and admission, the defendant himself will have admitted part of the claim you've made. And then you say that, court, look at what I said and what the defendant is saying. Clearly, this defendant has admitted what I'm saying. And the point about trial is for us to find out who is actually telling the truth regarding the claims, isn't it? So where the person has admitted, you have to prove that which is established already. That which is established does not call for further proof, isn't it? Yes. And on the basis of that, we want the court to give you judgment. But it's different from summary judgment. Summary judgment, you are making a bold claim that based upon what you are armed with, the information you are armed with, there's no way the defendant can actually resist this claim. So give me judgment. If you have to wait and go through judgment, there's nothing really to be tried. So don't let us waste time. So that one is different from saying that if I look at the defendant's pleadings, the defendant himself has conceded or has admitted what I'm saying. So on basis of that admission, give me what? Judgment. We are getting judgment in all cases, but the roots and the dynamics are what? Are different. Are we clear? Yes.
My Lord, please, with the explanation that you've just given with respect to the summary judgment, what happens to the rule of natural justice that says that you are supposed to hear the others? You are supposed to hear from them.
Yeah, I mean, for this question, you will still be given chocolate. So you just yeah, so her question is that if I understood her well, that if we are talking about summary judgments, how does that sit well with the natural justice rule? You must hear both sides before you do what? You decide. Is that your question?
Yes, ma'am.
Good. So, I mean, the natural justice rule is not necessarily sacrifice. It's embedded. It's still within the process or the procedure leading to summary judgment. Because it will be on notice, by the way. It's on notice with the defendant. The defendant has opportunity to also show a cause. Why summary judgment should not be what? Entered. We'll get there very soon. And of course, when it comes to the 14 at the rule 9, when it comes to certain aside, isn't it? Where there has been a breach of, let's say, natural justice, that would be a ground to set aside the summary judgment, as it were. Good. So let's move on. But we come to some of these issues. So if you read Mr. Kwame Tete's book, which I've asked you to read, particularly chapter 11, he will make the point that the summary judgment procedure is intended to prevent a plaintiff who is clearly entitled to relief from being delayed, quote, where there is no fairly agreeable defense to be brought forward. There's no fairly agreeable defense to be brought forward. Then you allow the judgment to be entered. At the end for nothing at all, the Supreme Court has the case of Sanunu against Salifu, which I would like you to read. I think at the Bafubon Road, the judgment. Sanunu against Salifu, 2009. Sanunu against Salifu 2009 SCGLR 586. And also the case of Ballast Nedam Ghana against Horizon Marine Construction. I've asked you to read the chapter 11. If you read it, they are all there. So because of the question which came up, and before we move on, summary judgment, before judgment, and striking out. What is the difference and what is the relationship? So first, for summary judgment, we just noted that it is a merit-based termination of proceedings. When I say merit-based, that is to say that we've looked at the merits of the claim. And then, based upon that, we're saying that there's no point for the proceeding to continue. Let's end it by giving the plaintiff what? Judgment. Because there's no fairly arguable defense, as Mr. Teta will tell us. So, if you are to do a trial, it will just be an exercise in futility, as lawyers want to say. No useful purpose will be served. But mind you, summary judgment is not about procedural default. It's not the case that the defendant has defaulted in not doing what the law requires. No. So let's get that in mind. It's not the case that the defendant has defaulted, let's say, in entering appearance or in filing the defense. That is why we're giving the judgment. No. All that we're saying is that the plaintiff is so sure of the merits of his claim and is able to demonstrate to the court that, assuming the defendant didn't have anything to say, it is never an answer to the claim that what I am making. For which reason, there's no need for us to wait any further. Allow me to sign a judgment. But mind you, and that is why we keep talking about bona fide defense. It does not mean that, so it doesn't mean that the plaintiff is saying that the defendant, defense cannot let him lose the case. No. So the emphasis is bona fide, good faith. In law, whatever the defendant may have to say, is there something which has some reasonable basis, for which reason we should give you the benefit of the doubt and look further into it. So that is the point. And if you look at the Ballast Nedam Ghana against the Horizon Marine Construction Ltd, 2010 SCGLR 453, for example, the Supreme Court made the point that summary judgment prevents the defendant from delaying justice through sham defenses. There's something we call the lawyer's defense. Lawyer's defense is sometimes you read the civil defense and you say that this is even bogus. That is not saying anything, but just that something should be seen to be found as what? As a defense. So that's a sham defense. So the basic point to note, as we are trying to draw a distinction, is that summary judgment is final. 2, it is entered after appearance. Appearance will be entered. And 3, it is based on affidavit what? Evidence. 4, summary judgment involves limited judicial evaluation or limited evaluation of evidence, in the sense that the court at this stage is only trying to find out whether there are triable issues. Are there questions of law or facts which will need to be gone into, for which reason there should be full trial, rather than allowing the judgment to be entered as well as a summary judgment. So that's a very limited evaluation at that stage. And the point to also note is that the court does not weigh evidence or assess credibility, as it were. So what will trigger a summary judgment as opposed to judgment in a default? What will trigger a summary judgment is absence of good faith defense or bona fide what? Defense. And the core question which the court will have to address in summary judgment, as we try to draw the distinction, is this: does the defendant disclose any defense known to law, which, if proved, will defeat the claim? That's the basic question. Does the defendant disclose any defense known to law, which, if proved, will defeat the claim of the plaintiff? If the answer is yes, summary judgment will be refused by the court. If the answer is no, summary judgment will be what? Will be granted, isn't it? Now, what about default judgment? Default judgment, as we saw in order 10, orders 10 and orders what? 13. Remember order 10? Judgment in default of what? Appearance. Order 13, judgment in default of what? Offense. Good. So unlike summary judgment, the default judgment here is actually a procedural sanction-based termination. The summary judgment we said there's a merits-based one termination. But default judgment, there's a procedure. You not comply with what the law says you should do. And that is why we are sanctioning you by allowing your opponent to have a judgment because they didn't do the needful. But in the summary judgment, it's not the case of having done the needful. We are saying that you don't have any proper answer to the claim, and that is why we are giving what? The judgment. So the basic premise in default judgment is procedural non-compliance. It's not futility of trial. Summary judgment, the basic premise is that trial would be an exercise in what? In futility. But in judgment in default of appearance or defense, it's just the fact that there has been non-compliance procedurally, and that is why it's being taken. In terms of the nature, a default judgment may be final or interlocutory depending upon the circumstances. But summary judgment is always final, so let's get the distinction. If I were your examiner, I'll frame a question around something like that, but thank God I'm not your examiner. So a default judgment may be final or interlocutory depending on the nature of the claim, isn't it? If you look at order 10, for example, we are told that, and we know in liquidator claims, the plaintiff will be allowed to have a final word, judgment. But in non-liquidator claims, the plaintiff will be allowed to have what? Interlocutory judgment, with damages to be assessed what? Later. And remember the case of Asamoah against Marfo. Remember that Asamoah against Marfo, where the court, speaking through and in the board, yes, as he then was, who say that in default judgment, the court cannot award more or less than what is claimed, isn't it? By in summary judgment, the court can award less because it can have a summary judgment in respect of part of the claim, not the entirety of it, as it were. So, what will trigger judgment, or default judgment? One is triggered by failure to enter appearance or failure to file what? A defense within time. And this is very mechanical. Default judgment, there's nothing like, there's no debate. You haven't entered appearance, you haven't filed defense. Unlike summary judgment, where there will be a debate as whether there are tribal issues or there are no what? Tribal issues. So the core question for the court when it comes to default judgment is basically that has the defendant failed to comply with a mandatory procedural requirement within time? There are timelines. You are supposed to file certain. If you haven't filed it, you haven't filed it. So if the answer is yes, a judgment will follow as a matter of procedural consequence. What about striking out? Because that has only come up today. Striking out, you are referring to order 11, rule 18. So it's not concerned mainly with determining rights, but it is concerned with removing defective or incompetent or abusive processes from the court's records, as it were. So it's not so much about entitlement or it's about default, but it's about the fact that someone has filed pleading or process which is defective, which is scandalous, which is an abuse of what? Of the court process, or which does not disclose reasonable cause of action or defense, as the case may be. Now, in terms of nature, striking out judgment or orders may be final or non-final. It depends upon the circumstances. In some cases, it may be final. And again, it can occur at any stage of the proceedings. It can also be done so motu by the court or mere motu. The court on its own, without even being moved. But summary judgment cannot be done by the court on its own. You know why? The court on its own cannot just give a summary judgment. Do you know why the court on its own cannot ex proprio motu grant a summary judgment? Can anybody explain? I think you need, yes. I need you to justify your chocolate. So can you explain? Yes. Yes, can you explain? Can you explain?
My lord, please can you repeat the question?
You were just fiddling with your phone, so you were not paying attention.
My lord, please, I'm sorry.
Okay. Yeah, so you want to help her? Okay, so try. If I correct, I have the discretion to relocate the chocolate. Sense? You're not eating it. When did you eat it? All right, let's hear her.
And my lord, you said that it's based on affidavit evidence that is tendered in. So if parties do not bring in any evidence, there's nothing the judge can do.
Yes, and it's about the plaintiff taking a position or a claim that I am so certain about the compelling merits of my claim that there's no defense cognizable in law which the defendant can put up to my claim. So don't need to waste or belabor the point. Allow me to have what? Judgment. So you are saying that so the judge on his own cannot just look at the pleadings and say that no, I think I'll give you what? No, that cannot be done. And now let's come back to our summary judgment, having seen the distinctions. Yes. The chocolate. Okay, so I think you are closer to getting one. So I'll call you. Then once yes. Because you offered it. It means that you have prepared the answer already. But I want it to come as a surprise. Yes. Yes, question, let's take it.
Please don't say that when the judge grants a summary judgment for this, and he says the judge is, we say that the judge on this one is creating things for trial. Because I'm trying to link it to on 11, where we have said that the judge can also this will bring out things for the party. So in such a case, when the judge
this summary judgment committee, when it has it, it has to time the party. Can we say that in a sense, the judge is bringing out his or her own?
Okay, maybe we put it that the judge is descending into the arena of conflict. Instead of staying on the frame, instead of being a neutral umpire, the judge is descending into the arena of what? The conflict. And trying to, and that will also be prejudicial. Because you are supposed to judge. So if nobody has requested you, how do you call the party and say that, looking at the statement of the claim, the court is satisfied that there's no way you defense can actually what? Answer this no. So the judge cannot do that. So in terms of the central basis, on the 14, we have to look at it well. The 14 is every student of the law should know it inside out. Or from the rule 1 to rule 12. So rule 1 will tell us when summary procedure may be invoked, as we've read. Rule 2 will tell us how the application should be made. Rule 3 will tell us how the defendant may show cause. And then rule 4 will tell us the type of affidavit required in summary judgment what? Application. And then rules 5 to 8 will tell us the powers the court has got when it comes to dealing with summary judgment application. And then rule 9 will tell us when the summary judgment has been entered, under what circumstances can it be what? Set aside. And also rule 11 will tell us after summary judgment, what happens to the rest of the case? Particularly so if the summary judgment in respect of a part of the claim. So continuation of the remainder of the action. So look at the order 11, order 14, rule 11. And order 12 will tell us about matters which are excluded from summary judgment. And I'd like us to discuss that before we move on. So what matters can you not get a summary judgment? What matters are excluded from what? Summary judgment. Or somebody hand up without prejudice to claim for chocolate. All right.
My Lord, I want to believe that during the hearing, as far as the application for summary judgment is concerned, it must not enter into the merits of the case. Because we are now looking at whether or not the issue being pleaded are triable. Now, my question is, how does the court guard against entering into the merits of the case? Because at that particular hearing, you're not supposed to focus on the merits of the case.
No, summary judgment, you focus on the merits of the plaintiff claim. And that is why, if you look at the procedure, we're discussing very soon, the plaintiff will have to support the motion with affidavit. And then the affidavit, he can exhibit all documents, all other things. And that's why we say that summary judgment, summary trial. So if you have documentary proofs, you have any other thing, you can exhibit it. And you are saying that you are doing some kind of front loading. That look at this evidence that I have. There's no way the defendant can actually what? Overcome. So if he's allowed to file his defense, it will not really change what I'm saying. Allow me to have what? Judgment. Now the defendant will definitely resist. He would like to show cause in his affidavit opposition, or he may even file a statement of defense or propose a statement of defense and attach it to affidavit opposition and say that I have a defense which raises tribal issues, for which reason the plaintiff should not be allowed to sign what? A summary judgment. So there will be some consideration of the merits of the plaintiff's claim. Yes.
Very well. So I asked that because if the application is dismissed, then the issues must be tried.
Yes.
So in order not to do a repetition of the work that was supposed to be done, because if the application is dismissed and the issues are being tried, now we have to enter into the actual facts or actual issues for which the plaintiffs are brought to the court, right? So I'm looking at how, at the point of hearing the application, as far as the summary judgment is concerned, the level of details that are entered into vis-a-vis in the instance where it is dismissed, the level of details that will be looked at when we are actually trying the case.
So where summary judgment, for example, is unsuccessful, from the litigation strategy point of view, you, the plaintiff applicant, you of course, it's not really lost much because of the rules on discoveries as well. Like you have actually made available the weapons from your arsenal, like the proofs that you have. So the defendant already has the idea, isn't it? And then if you have like a defendant who is very smart, especially now that's going to file signal defense, he can pick up on certain things and use it to formulate a certain defense. Sometimes defendants have all manner of objectives. Because when I was a practitioner, I have some cases, especially when it comes to loan recovery. I'm defending the debtor. And I've worried banks so many times. There are some cases I drag it for many years. I knew my client does not have a case. But that was not the objective of my client. My client's objective was that, like, whatever you can do to delay the case and then know that. And then we were also doing it. So defendants have all manner of what? Objectives. And that is how it is. Of course, if you're a lawyer and you advise your client to concede, and then the person will not concede, either you stop representing him or you try and look at the law, what can be won, what can be done. So what matters are excluded from summary judgment before we look further. So the 14 to 12. Summary judgment, as we are told, is available in any civil action once the defendant has entered appearance, so long as the exclusions in order 14 to 12 do not what? Apply. Now, what are the matters which have been excluded from summary judgment? In other words, if the case is about that, then summary judgment rule does not apply. You cannot go for summary judgment. If you look at order 14.12, that we are told summary judgment shall not be given under this order with respect to probate, matrimonial or maritime proceedings. B, a claim or counterclaim for defamation, malicious prosecution, seduction or breach of promise of marriage. Or C, a claim or counterclaim based on an allegation of what? Of fraud. So a summary judgment cannot be invoked in any of the following circumstances, isn't it? Good. So the reverse is true, that if you have all other cases like contract, torts, of course, torts, some torts are excluded. What are those excluded? Defamation and what? Malicious what? Prosecution, good. So those are excluded. Debt recovery, all commercial transactions, land disputes, especially where we have a clear documentary basis, maybe like something like a land title, the certificate, for example, and other causes of action. But apart from that, if we come to the matters that we have mentioned, the court will dismiss the application as being incompetent and limine, because the law says that summary judgment is not what? Available. So probate proceedings, why are they excluded? Probate proceedings, if I say probate proceedings, you know what I'm talking about? Yes. Where someone, a person has made a will, and then the will has been admitted to probate. And then in terms of order 66, somebody is trying to contest either the will, or somebody is contesting the grant of the probate. Either you are trying to prove the will in simple or solemn form. These are all probate actions. And the law says that you cannot get a summary judgment. Why is it so? Because it is fact and relationship sensitive. There'll be questions of testamentary capacity, isn't it? Questions of undue influence, maybe competing family claims. And all these things will require some kind of evidence, not only documentary evidence, overall what? Testimony. And summary judgment will not work. The maritime proceedings, maritime proceedings, matters relating to what? Relating to ships, isn't it? Charter parties and so on. I'm not talking about the matrimonial. I said maritime. Yes. So maybe like you have like charter party agreement relating to ship, so the marine industry. So over there, we have complex questions, some international elements, technical questions of seaworthiness, cargo handling, and so on. And some specialized admiralty procedures. And you cannot use summary judgment, and that is why they are excluded. Yes. Yes. The 14 or the 14 rule 12. You mean rule 12? 12A. Was that no matrimonial? Or of course, matrimonial, that is marriage, divorce and stuff. Yes. Good. So that is why we are doing interpretation later on. And that is why, sometimes disjunctive may mean conjunctive, isn't it? It will depend upon the context. Yeah, so you are right. The impression we created, whether matrimonial and maritime are more or less the same. Yeah, you are right. And that's an inappropriate use of the word or. And I think for this ingenuity, I use my discretion to confer one chocolate on you. Yes. No, but then I'm not being fair to the lady over there. So come for yours. So, all right. So we are also told that when it comes to fraud, or claims or counterclaim based upon fraud, you can also know how the summary judgment. So let's get that clear. When we are practicing law, if we have a claim or counterclaim involving fraud, don't think of the word 14. Don't think of the 14. Yes.
It's unfortunate with respect to the A.
Probate,
yes.
Patrimonial or maritime.
The maritime is with the explanation you gave. The maritime is included because of the speciality, the technicality of that sector. What about the aviation sector when it comes to oil? Is that sector also not technical? So is there any particular special reason why we get through maritime?
Yeah, well, usually we don't have aviation, you don't have like a lot of aviation litigation, but the maritime is very common when it comes to harbors and things like that. Aviation, you usually get and we have like the international regime when it comes to accidents and other things like that, which govern it. But you are right. The emphasis, except that an argument could be made that issues of admiralty in modern times, you have to be interpreted liberally to also accommodate aviation. But if you look at it historically, shipping is very old. It's one of the oldest transportation industry, isn't it? So from the common law, the maritime, over thousands of years. If I like the shipping business there, isn't it? Yes. But then when it comes to aviation, it's relatively recent, isn't it? The aviation is relatively recent, less than 100 years. Yes. That's the scale that we have. But maritime, if I like the ship, if you go to those who know the Christian Bible, as far back as the 2000 years, we're talking about ship, isn't it? Yes. Somebody mentioned no one. Yeah, so malicious prosecution, defamation, seduction, breach of promise of marriage. because of their complex nature. Defamation, for example, we need to now interpret whether the alert things, the meaning, innuendo, justification, fair comment, and damage reputation, all this will have to work out. And that is why summary judgment cannot be what? Cannot be permitted under the 14. You need to resolve them with evidence, including oral evidence. Malicious prosecution too, the same thing. There's a lot of probing that we need to do. And if you look at summary judgment, largely where you have documentary what? Just a documentary basis. So you just lay everything there as part of the affidavit and say that these things support my claim, and the defendant cannot actually defeat this. So allow me to have judgment. So you're not going to say that we need to come and cross-examine what? Somebody extensively and so on, as the case may be. When it comes to seduction and the breach of a promise of marriage, can you do breach of promise of marriage and seduction without actually taking oral testimony? You can't do that, isn't it? Yes. So affidavit evidence alone will not work. If there's affidavit evidence, you may need to cross-examine the deponent, as it were. Order 14, Rule 12 looks simple, but I want you to pay attention to, you can be given something like a scenario or something, and you must always be aware if those elements are there, why it would be wrong for the judge to have granted summary judgment or somebody to ask for it. Yes. Yes, let's take it before we look at the procedure. Yes.
My Lord, respectfully, I come under order 14 rewards.
The 14 reward, okay.
The effect that a plaintiff who, having considered that the defendant has no reasonable defense or the defense could fix.
Yes.
Time for
summary judgment.
When you do that, Rule 5, sub-Rule 2 of the same order.
Yes.
Says that the court may, subject to any condition that the justice of the case have, stay execution of judgment given against the defendant, and that this will until after the trial of any counterclaim raised by.
Yes.
And what my question is, the defendant in this case has been filed a defense to even talk about having a counterclaim. Yet the rule is saying that
God may stay.
Must stay. Or may stay. My Lord, in the case of progressive export and import spoiler, you gave us to be. It's to the effect that, but the lawyer in this case submitted to judgment. So there was an application for summary judgment, and then he submitted, said he had nothing to file.
The party submitted to judgment.
Yes. And after the judgment has been given, the summary judgment, if they wanted to file an application to set aside
the summary judgment,
and in his application, he actually added a counterclaim coming under this particular subgroup, saying that it is because of such possibility that the lawmakers or the rules of court added this provision. The court gave an interpretation for it is the plan before
before the summary judgment is determined. Yeah.
So my question then is, if the defendant hasn't filed any document of defense,
how will the court know?
in which he would have his conduct, then where would this conduct be?
Oh, good. Okay. We are coming there, but it's pretty straightforward. Where the application is brought. Okay, now because of the potential of abuse of this chocolate privilege, I've suspended it for the next 1 hour. We'll resume after 1 hour. So now the chocolate distribution is suspended for 1 hour. Good. So coming back to the question, where the application is filed, supported by affidavit by the plaintiff applicant, is on notice to the defendant. The defendant will file his affidavit in opposition. And there are two things. The defendant will file his affidavit in opposition, and the affidavit in opposition set up whatever he's going to put in statement of defense. And any counterclaim that he may want, he may include that in affidavit directly, or as a way of showing cause why there are tribal issues, or he may just do the affidavit in opposition, and after everything, he will exhibit a proposed statement of what? Of defense. Or sometimes may not even say proposed, may just file the statement of defense and counterclaim and exhibit it to the affidavit in opposition. And then on the day of hearing the application for summary judgment, he will put up the argument that based upon the things he has canvassed, the position affidavit in the opposition, and also the proposed statement of defense or whatever, if they are considered, they raise serious questions which cannot be resolved unless the court has gone into full trial. And for that matter, it is premature for the judgment, for the plaintiff to be given a summary judgment. So here, if the court, for example, is so persuaded and grants, or it may also be that the court will say, okay, we are not sure about the defense we are saying, it will actually defeat the plaintiff claim. But then we've seen the counterclaim that we are setting up. So since the counterclaim is a distinct cause of action, we will allow the summary judgment to be entered, but the plaintiff will not be allowed to go into execution of the summary judgment. It will be stayed pending the determination of the counterclaim. So that can also be done. Yeah, so that can also be done. But we come back to this. So let's look at the precondition for invoking summary judgment. What are the preconditions? So let's look at the procedure in detail. So first, summary judgment under Order 14 is not available as of right. So that's the first thing we should note. It's not available as of right. Unlike the default judgment we saw, those are available as of right, isn't it? Because there are timelines. If the party has not filed, you just go to the court and tell the court, and the court will grant it. But summary judgment is not available as of right. Certain preconditions are foundational. One, entry of appearance. And two, complete defect-free statement of claim. So let's say them one after the other. So entry of appearance. An application for summary judgment can be made only after the defendant has entered appearance. Meaning that if the defendant has not entered appearance, you cannot go for summary judgment. You go for judgment in default of appearance, as the case may be. So look at the case of a Kuma against Bad Planch. Kuma against Bad Planch. 1989-91 JLR 119. There, the court held that an application for summary judgment filed before appearance is incompetent. So where you file application for summary judgment, there has been no appearance, that is incompetent. Why is it so? Because summary judgment presupposes that the defendant has come before the court and is in a position to show cause why judgment should not be what? Entered. What is the point about appearance? Appearance, the defendant is saying that, yes, I'm aware I have been sued. So I'm also before the court. Now, when that has been done, then you, the plaintiff, can come to the court and say that due to XYZ, which I put in my affidavit, I think that the defendant cannot actually answer my claim. So allow me to have what? Judgment. Then the defendant is already in court by the appearance, and then he was making effort to show cause, to demonstrate to the cause why summary judgment should not be what? Entered. And that is why it is wrong, where there has been no appearance, for you to rush and get the summary what? Judgment. So the case of Yatel Boat Building Company, Yatel Boat Building Company against Annan, 1991 2JLR, page 11. The Court of Appeal made the point that summary judgment is not a substitute for default judgment. So let's get it clear. Summary judgment is not a substitute for what? Default judgment. So if the defendant has not entered appearance, then the remedy of the plaintiff lies not in summary judgment. Where does it lie? Lies in default judgment. And the reason is obvious. Default judgment, as we have seen, responds to procedural silence or non-compliance. But the summary judgment responds to procedural participation without substantive vote, defense. The person is participating, but he doesn't have defense. We also made the point that there should be a complete and defect-free statement of claim before you can have a summary judgment or the 14. And if we look at Mr. Kwame Tete's work, he will make the point that summary judgment is available only where the statement of claim on its face discloses a sustainable cause of action without material defects. Now that statement is quite important, and we need to digest and let it sink in. All that is reminding us, and rightly so, is that if you are the plaintiff, you are going to apply for a summary judgment. Your statement of claim must not sin against, for example, one of the things in the 11 rating, isn't it? And that's why we're saying that your statement of claim on its face must disclose a sustainable cause of action without material what? Defect. So all the things which can let your statement of claim be amenable to striking out under the Levin rule what? Or the Levin rule 18, that should be on your fingertips, or the Levin rule 18, should not be applicable to you, the plaintiff, as far as your statement of claim is concerned. And then the point is made that the affidavit, which is supposed to accompany the application, is not a vehicle for curing deficiencies to a defect in the statement of claim. So therefore, if there are problems in the statement of claim, don't think that because of the 14 will say that the application must be accompanied by affidavit, and then the affidavit, if you use it to cure whatever problems you have in the statement of claim, no. So if you have a substantial defect in the statement of claim, it cannot be cured by affidavit and will result in the dismissal of the summary judgment vote application. So if you look at the old case of Gold Oris Reduction Company, gold, as in gold, the mineral gold, Oris, O-R-E-S, Gold Oris Reduction Company, against Payne, P-A-I-N, is a 1892 2QB 14, where that point was made that if you have a defect in your statement of claim, it cannot be cured by affidavit, accompanying application for summary word judgment. So, in practical terms, defects such as failure to plead essential elements of the cause of action, as we've seen under order 11. You know, under order 11, there are certain material particulars which should be what? Pleaded for certain types of causes of action. If you don't plead them, that means that there's a problem of the statement of claim. Or you have the fact like internal inconsistency in the material facts. Internal inconsistency, including departure, or the level reward. 10. Defendant your chocolate. All right. Yeah. Then there should be no absence of necessary particulars. So if there are certain particulars which are needed under the law, we saw this under 11-18. When you have those things, then you need, for example, let's say that you are seeking to have, let's say, the contract rescinded, and you've probably pleaded the misrepresentation or some other vitiating factor, but you don't give us the material particulars or the necessary particulars. So any of those defects practically can defeat summary judgment application. So if you have those problems, you solve them by amendment and order system, which we'll be discussing. Now let's talk briefly about timing and relationship with pleadings. That's another confusion. When can you bring summary judgment? And we've had yes. Yes. So no, I think somebody's at the back. And I'm sure he's aware that we have suspended all right. So once we are clear in our mind.
Hello.
Yes.
My lord.
Yes.
So I'm motivated by the chocolate today, but my question is, assuming.
So you see, there's a clear example of a defect in the statement of claim. You are coming for summary judgment. You'll be told that chocolate has been suspended. Then you start by saying that you're motivated. All right.
My lord, assuming somebody, a plaintiff, I'm the plaintiff.
Yes.
After filing my application, and the defendant enters appearance, but then after 14 days, the defendant fails to
do the defense, file defense. Yeah.
Should I go for judgment in default of defense, or should I go for summary judgment?
So once appearance has been entered, once appearance is entered, you don't need to wait for the 14 days. You don't need to wait for defense. All that is required is that appearance has been what? Entered. And the entry of the appearance is just evidence that the defendant has acknowledged the pendency of the action against him or her. So, yeah.
My lord, my question was, I'm at the lawsuit. Should I wait for 14 days to elapse? Then I'll go for judgment in default of defense, or should I just apply for summary judgment in between before the 14 days?
We talk about two things. The standard or the threshold which should be met for summary judgment is very high. But the threshold for judgment before the defense is just the procedural default. After the 14 days, that is the basis for you asking for judgment. Has got nothing to do with whether, as a matter of fact, the defendant has defense or doesn't have what? Defense. But the summary judgment, you need to actually prove that the defendant does not have a defense to your claim. So there are two different things. There are two different things. Yes.
I was going to ask, what of if it's a conditional appearance?
If it's a conditional appearance, appearance is appearance, isn't it? Whether conditional or unconditional appearance. Because conditional appearance, okay, the argument to be that he may want to set aside, let's say, the rate. So because of that, technically, it will not prevent you from going for the application, but when you go, the defendant will come and say that, well, I'm still within my right. Having entered conditional appearance, I'm bringing application to either set aside the rate or raise some challenge. So for that reason, it's not prudent when conditional appearance has been entered for you to rush with the summary word judgment. Because the conditional appearance itself is a signal of a challenge to competency or some aspect of the yes. So we need to know why. And even you from the strategic point of view, the plaintiff is in your interest wait for that to go, so that you are sure that the defendant cannot really raise anything. Now, I brought up this issue before the question came that, there's a confusion as to whether you can have a summary judgment after senior defense has been filed, or it cannot be held. So if you look at Gasub against Dizengov, Gasub against Dizengov, Gasub is a GHASSOUB against Dizengov, DIZENGOFF. 1962 GLR 133. It's a Supreme Court decision. And Akufo-Addo is not the president, his father. He made the point, or he explained that once a defendant has entered appearance, the plaintiff has two procedural options. One, to apply for summary judgment and thereby throw upon the defendant the burden of showing a prima facie defense. If we say prima facie defense, trying to say that assuming what we are saying is true, assuming, we're not saying it's really true, assuming what we are saying, I'm saying as a defendant is true, it answers the claim that the plaintiff is trying to make. And for that matter, it should not be allowed to have both summary judgment. Or two, the other option, to waive the summary procedure and proceed on the defense and allow the matter to go to trial in the ordinary course. So therefore, from Gasub and Dizengov, we can say that summary judgment is not a must which a plaintiff has resort to. You have no obligation to trigger Order 14. And in fact, if you are not so much in a hurry, avoid Order 14. Allow the matter to travel its course, isn't it?
Yes.
So if you look at Order 14, Rule 9 says that under appropriate circumstances, the court can set aside the judgment entered in summary word judgment, isn't it? Is that not what the 14 Rule 9 says? Yes. So it's not mandatory that you should use that. It's just an optional, if you like, a procedural shortcut, but not a mandatory stage in litigation. And that is why in the case of Atlanta Timber Company against Victoria Timber Company Limited, (1962) 1 JLR 221. And just an answer to our friend's question. There, the court said that the plaintiff had the right to summary judgment despite the filing of statement of defense by the defendant, provided the defense disclosed no triable issue. So provided it disclosed no triable issue. So therefore, it does not mean that once statement of defense has been filed, then the door is shut for summary judgment. No. Summary judgment, you can bring it when signal defense has been filed. If you can demonstrate that the signal defense does not disclose any triable issue, as it were. Except that you cannot go for summary judgment before there has been entry of what? Appearance. But if you look at the case of SCGLR Ghana Limited, SCGLR Ghana Limited against Aluminium Enterprise Limited, the Court of Appeal gave a decision which a view is held that is per incuriam. You know, per incuriam decision. When can we say that decision is per incuriam? Yes, my friend in front, you got the chocolate but haven't justified much. Yes, per incuriam. When can we say that judgment is per incuriam? Okay, at least you have an idea. Yes, can anybody straighten it? They said they didn't hear. Yeah.
When it runs pari passu to another person who that is already existing.
Fine. You know, if you do that, you're reminding me of this scholar in Nigeria. He's called have you seen the man? No, there's this gentleman in Nigeria. He uses English words like anyhow. And then, no, really. And then when he speaks, you need to go and take a dictionary and then look up the. Oh, there's this. You don't know him. This one is or here about something. Yep. Okay. Yes. Anyway, I'll look for him during the break time. Yes. So you use English, don't use Greek to explain.
When it runs opposite, like it's opposite another principle that is already. Please, did you hear me?
So anyway, just to make it simple, of course, the Supreme Court is superior to the Court of Appeal. So where the Supreme Court has a decision which is relevant to a matter, and let's say that the Court of Appeal, for example, ignores it and come to a decision which runs, let's say, contrary to what the decision president has said. So that is an example of an incurium. Or we have a legislation which is relevant, which was also not taken into account. And per incurium can be committed by court at any level, not only the lower courts, but even Supreme Court can also commit what? Per incurium, as it were. Particularly so, the Constitution says that Supreme Court may follow a decision, but can decide to depart from it, where it appears to right so to do, isn't it? So the thinking is that not until they expressly demonstrate that due to X, Y, Z, we don't think that the decision is still a good decision, let us depart from it. They are bound by their own decisions. So I mentioned the case of SCGLR Ghana Limited against Aluminium Enterprise Limited. The Court of Appeal decision reported 1999-2000 SCGLR 113, in which the court suggested that summary judgment ought to be brought before the defense is filed. Now, if you juxtapose that with Kasum against Dizengoff and also the Atlanta timber case you mentioned, you will notice that there's a problem, because those two Supreme Court decisions suggest that even where civil defense has been filed, it does not prevent application for summary judgment, provided the plaintiff applicant can demonstrate that the civil defense does not disclose any triable issue. So let's look at the method for applying for summary judgment. Yes. After the method, we have the break. Yes. So method of the application. And everybody should know how to do this, how to apply for summary judgment. So application for summary judgment must be brought by motion or notice. That is the first one. If you look at the 14 rule 2, it should be brought by motion on what? On notice. And what must be stated in the motion? The motion must seek the judgment itself. That is the judgment you are looking for, isn't it? And not leave to enter judgment. So let's look at, if you look at the 14 rule 2, which says that, no, even let's have if you look at the 14 1, if you may on notice apply to court for judgment. Didn't it say may apply to court for judgment? Did it say that may apply to court for leave to enter judgment? Yes. So you apply to court for judgment. Or maybe it may look pedantic, but in the past, in the case law, there was a distinction between asking for judgment and asking for leave of judgment. If you look at the case of a Clifford against Gandhi, but that is not important, very old case, don't worry. So if you look at Order 14, Rule 2, it says that the notice of application shall set out the reliefs sought by the plaintiff. So you must frame the prayer, what we need in terms of summary judgment in the motion paper, in the application. Of course, you have to go back to the endorsement on your rate of sermons. Those are the reliefs you are looking for. So if you are looking for summary judgment, either you are looking for summary judgment for the entirety of the reliefs, or if the summary judgment cannot really apply to the entirety of the reliefs, only portion of it, you have to specify those aspects of your claim in respect of which you want the summary what? Judgment. And if you look at it, the rules allow for severable part, meaning that you can carve portion of the claim and ask for summary judgment. And then the rest of the case will continue in the usual course of things. Or somebody talk about admission. If there's admitted the portion and Order 21, Order 23, you can also get it. Now, there should be supporting affidavit. Supporting affidavit. And the supporting affidavit, in terms of Order 14, Rule 2, which says that the notice shall be supported by an affidavit verifying the facts on which the relevant claim or part of the claim is based, and stating that in the deponent's belief, there's no defense to that claim or part of a claim, or no defense except as to the amount of any damages or claim. So the affidavit is supposed to do two things. In your statement of claim, you have alleged facts. So in the affidavit, you are supposed to swear to confirm those facts, which you think support the claim that you are trying to get a judgment on. And that would include if there are documentary exhibits, you exhibiting them. So maybe like, for example, if it's a debt recovery, you have to exhibit the underlying transaction, the agreement, the payment made, demand notices, and so on and so forth. All documents which actually support what you are trying to claim, you exhibit it. And the second aspect, which should be taken care of by the affidavit, is the fact that you are saying that in your honest belief, the defendant has no what? No defense to the claim that you are making. So if you look at the case of Cowries Finance Limited, Cowries Finance Limited, Cowries, that's a Cowrie, Finance Limited against Paco Bay Seafood Limited, Paco, P-A-K-O, Paco Bay Seafood Limited, 1999-2000, 1JLL 514. The Court of Appeal explained more about this affidavit, which is supposed to verify the facts. And the court made the point that the affidavit will set out in substance the transactional facts. That is the transaction underlying the claim you are looking for the relief or the judgment. And here, it's not the form which is important, but the substance. So maybe if it's about contract, you have to set up facts showing the existence of the contract. 2, facts showing performance by the plaintiff of the side of the contract. And 3, showing actions or omission by the defendant who suggest breach by the defendant. And then the sum due or being owed by the defendant. But if your affidavit is just skeletal, in the sense that it does not give enough information, including supporting proofs, the court will not entertain your application. Yes.
The first say doesn't include the amount to be claimed.
The amount.
Yes.
Yes, so yes, the amount to be claimed is part, especially if you are looking for part of the amount. If let's say that if the rate that you are seeking to recover is say 1 million Ghana cedis, but then you know that the documents that you have, when you do the addition, you can only prove 500,000. Then you need to indicate the portion as it were. Because if you succeed in getting summary judgment for the part, the other part is still a candidate for trial. You still have to continue with the trial for you to show whether, as a matter of fact, you're entitled to it or you're not entitled to it. We talk about the second portion, expression of belief that there's no defense. How do you do that? And what is the point? First of all, affidavit is a statement on oath, isn't it? So you, the plaintiff, you are swearing an oath saying that your honest belief, due to X, Y, Z, you think that the defendant does not have any what? Defense to the action. And for that matter, any trial would just be a waste of time. It will be an exercise in what? In futility, as it were. So in the affidavit, you say, I verily believe that the defendant has no defense to this action. Apart from all the things we say, you must have a statement similar to that substance, that you believe that the defendant has no defense what? To the action. So that if you've set out enough information about the transactions, but you don't throw in that statement, your affidavit is not complete, isn't it? But if you look at under 14 rule 2.2, it says that the notice shall be supported by affidavit verifying the facts on which the relevant claim is based and stating in the deponent's belief that there's no defense. So there are two conjunctions. Apart from you verifying the facts, your affidavit must also say that in your honest belief, the defendant has no defense. So if you are drafting, and these are some of the small technical things we can learn to whip when you are a practitioner, if you don't pay attention. If you've done all the affidavit, supported everything, and you don't throw in the magic statement that will be advised, and you believe same to be true, that the defendant has no what? Defense. That one alone can be harped on and used to dismiss your application. Because Order 14, Rule 2.2 says that the affidavit should do two things: verification of the facts, and also statement that you believe that the defendant has no what? No defense, isn't it? So if you've done only one and the other one is not there, you haven't met the requirements of the law. So who may depose to the affidavit? And in fact, just before I move on, reading Kwame Tete and I run it again. That statement that I said, that I believe that the defendant has no defense to this action, is not just formality. It's part of proper invocation of jurisdiction of the court for summary judgment. Because if you haven't said that, then the way is not clear for the court to consider giving you what? Summary judgment, isn't it? So who may depose to the affidavit? It may be sworn by the plaintiff personally, or a responsible and duly authorized officer or agent, particularly if you are dealing with like a company or corporate entity with direct knowledge of the facts. So if the deponent to the affidavit is not the plaintiff himself, and let's get this clear, where the deponent to the affidavit is not the plaintiff himself or herself, the affidavit must disclose the source of the deponent's knowledge. In other words, the things that you are saying, how did you get to know them? Is it the case that you have been told by the plaintiff or whatever? So you must disclose that. And two, you must also provide basis of the authority to depose. What authority do you have to speak to these matters on oath, on basis of which you are going to use to give a judgment for the plaintiff? Is it the case that the plaintiff has authorized you? If the plaintiff has authorized you, do you have a power of attorney, for example? Assuming it's not the corporate entity. If it's not the corporate entity and you've been authorized, you must have a power of attorney, isn't it? Either you have a power of attorney or you're a lawyer who have been hired to represent the plaintiff. You'll be given information. And then based upon this, you believe that the defendant has no what? A defense, as the case may be. So if you're a lawyer and you're going, of course, the Supreme Court, a number of occasions have actually decried the practice of lawyers deposing to affidavit. Well, there are certain matters in respect of which it will be all right if a lawyer deposes to affidavit, but there are other matters too, which is better to have the party. Now, the disadvantage of having a lawyer deposing to affidavit is that anytime there's an affidavit and the court, when the court is dealing with application, I think there's this case, the judicial rule came from like the Kofoldria, party, forgetting the title of it. But the point has been made by the court that when a court is dealing with application, the court has the power to decide how best to deal with the application. So if the court ex parte is in a law is good. Who said that? Who said that? Is it the chocolate? I don't tell you the chocolate. All right, good. See, I want more of such people who will say both of them. Good. Good. So if the court, for example, decide to suggest, maybe allow or somebody to cross-examine, if there's affidavit, the deponent of the affidavit can be cross-examined. So assuming you are the lawyer, you depose the affidavit, and then the court is looking at it, and the opponent has made the application to the court that due to maybe deposition 4 and 5 and 6, I would like to cross-examine the deponent on it, my lord. And then the court looks at it and court said that no, these are legitimate requests. So face a date, the deponent should enter the box. And if you are the lawyer, you enter the box, you can see the complication and embarrassment, isn't it? And even if you are not lucky, because an oath, if it turns a little on that maybe like you've told a lie, that's perjury. It can also have implication for your professional license, isn't it? Yes, so that's why you need to play safe.
So sir, is that why, sorry,
Yes.
is that why when you say that they been informed by their counsel that they very believe safe to do and all that? Is that the reason behind that?
Yeah, so yes. So let's say that you are not a lawyer. In terms of the verification of the facts, you can just speak because you are the source of the information. But then when it comes to the second part, that you verily believe that the defendant has no defense. You are not a lawyer, so you are not in a position to know that, isn't it? So it's your lawyer who have advised you, that have been advised by my lawyer, and verily believes him to be true, that the defendant has no defense to my claim. Yes. Now, just before I go for the break, let's look at, in practice, how we draft the motion of notice for summary judgment. So you have like the, you have something like like you have the heading, of course, the courts, the forum. The particular court is there, maybe the High Court of Justice, and so on. And then the suit number, the title of the case, maybe ABC Trading Limited against SYZ Enterprises Limited. Then you have the heading, motion or notice for what? Summary judgment. And after that, you have the prayer. Take notice, or as I said, somebody will say that motion or notice by, or somebody will say that take notice, they're all the same thing. So take notice that this honorable court will be moved on the day of. And and then applicant may be heard, praying the court for the following reliefs. 1, another entering summary judgment in favor of the plaintiff applicant against the defendant respondent for the sum of, let's say, 500,000 cedis, being part of the plaintiff's claim in respect of goods sold and delivered. 2, interest on the sale sum at the prevailing commercial rates, indicate from maybe this date to the date of final payment. Then maybe 3, costs. And usually when you do motion, they have what they call the omnibus prayer. And they will add, and for such further order as the honorable court may deem what, deem fit, then you put it there. Then you must have the grounds of the affidavit, isn't it? So the grounds of the application. And you have to do that in the form of the affidavit. You don't need to, so when you do the motion paper, you will add that upon the grounds set forth in accompanying what? Affidavit. That is 1. Or if you have to set the grounds on the motion paper to make the motion paper clumsy, so just after the relief, the particular prayer you want, then you add, in terms of or upon the grounds set out in accompanying what? Affidavit in support. Then you have the dash, the lawyer will sign, the solicitor's number, then the registrar, isn't it? Then the copy for service on the defendant respondent book. Now you come to the what you call the affidavit. So now you come to do the affidavit in support. So the affidavit in support, you have the court heading as just like the motion. You have the court and then the parties and everything. Then you have affidavit in support of motion for summary judgment. Sometimes some will say that affidavit in support by so and so in support of motion for summary judgment, or as the case may be. Maybe you say like John Mensah. Maybe I, John Mensah of Accra, so and so do hereby make oath and say. Then you know how to do the affidavit. You drafted it before, isn't it?
Yeah.
You practiced that 20. So you set out. So the first paragraph, you let us know who you are. And then when you make affidavit too, don't forget, you must always include that you make oath and say. If you don't include that, your affidavit is defective, isn't it? Because it's that which is letting us know that it's a sworn word statement before the commissioner for oath will come in, as the case may be. So maybe that I'm the finance manager of the plaintiff company, and by virtue of my position, I'm conversant with the facts of this case and competent to dispose of this affidavit. So we see how it is done, telling us about how you came by the information and also the source of your authority to speak to the matters in the word affidavit. Then let's say too that on or about 15th January 2024, the plaintiff, I'm just giving you a sample, so just follow. The plaintiff entered into a written contract with the defendant for the supply of industrial equipment valued at 750,000 Ghana cedis. 3. That pursuant to the said contract, the plaintiff supplied equipment to the defendant between January and February 2024. Copies of the delivery notes and invoices are attached and marked Exhibit JM1. So here, you are going to exhibit all the delivery notes, all the invoices and everything to support the fact that you have carried out your obligations under the contract, isn't it? 5, that despite, 4, that the defendant had paid the sum of 250,000 cedis towards the contract price, but has refused or neglected to pay the outstanding balance of 500,000 Ghana cedis. 5, that despite repeated demands, defendant has not disputed receipt of the goods, nor the outstanding balance. So you can even see attached demand notices. Maybe if you've done about 2 or 3 demand notices, you can even also exhibit them as it were. And if there's a reply from the defendant, and the reply, the defendant does not actually seem to deny what you are making the demand, you can exhibit all to help you to prove to the court that the defendant has no defense to the 500,000, whatever that you're looking for, as it were. Says that the defendant entered appearance, and this is important, that the defendant entered appearance in the plaintiff's rate of sermons. So your affidavit should reflect that fact, isn't it? That is entered appearance. 7, that I very believe that the defendant has no defense. The plaintiff's claim for the said sum of 500,000, maybe except as to damages, if any. Says that the fact deposed to herein verify the material averment contain the plaintiff's statement of claim filed in this action. So what will happen is that if you don't do this, you also have to even exhibit the statement of claim, or you can have a statement in the affidavit that at the hearing of this application, my lawyer shall refer to the processes filed as if same have been incorporated expressly in this affidavit. Of course, at that stage, not much will have been filed. All that you have the rate of sermon, the statement of claim, and the appearance, or in some cases, the defense, as the case may be. So that are deposed to this affidavit support the plaintiff application for summary judgment in accordance with order 14.2. Then you are done. Sworn at Accra, so and so, a deponent before me, commissioner for oath, as the case may be. So one drafting error you should avoid is that the motion, don't say that you are seeking for leave to enter judgment. That's not what the rule says, isn't it? If you look at the 14 rule 1, it doesn't say that. Does it say that? It doesn't. Yes. And then again, if the affidavit is to be sworn by a counsel, which is a bad practice anyway, should it be done? So I will even say that it should be sworn probably, if not the plaintiff, it should be by the clerk of the counsel. And then the clerk must explain the basis of the knowledge, isn't it? But if the plaintiff is there, why not allow the plaintiff himself to depose? And again, avoid the error of failing to state the belief that there's no defense. It's a magical statement which should form part of the affidavit. So, for example, if in examination, you have to draft, let's assume the scenario is given, then draft the necessary processes. And let's assume that you have to draft the motion for summary judgment on the 14th, and then accompanying affidavit. And if I read your depositions and I don't see any deposition to the fact that in your belief there's no defense by the defendant, you haven't done justice to the work, isn't it? And you've done the wrong thing. Yes. Any question before we go for 5 minutes break and then come back? Okay, so please, just a 5 minutes break. So we have a 5 minutes break now. So welcome back from the break. Yeah, so we have learned how to draft the motion for summary judgment, then the accompanying affidavit. And just to remind us, we said that affidavit must do two main things: verify the facts which the plaintiff is relying on for the summary judgment, and also indicate that in the plaintiff's applicant belief, the defendant has no defense. We made the point that where that statement is not added to the affidavit, it will make the application for the summary judgment incompetent, because if you have not shown the court that the defendant has no defense, you are not ready for the court to actually grant a summary judgment. And that is why it's a very important deposition in the affidavit to be made. And let's talk about service of the application. So if you look at Order 14, Rule 2.3, we are told that the application and the supporting affidavit must be served at least 4 clear days before the return date. So 4 clear days before the return date, meaning that if you file the application for summary judgment, let's say today, if you file it today, today is a Friday. And if you look at Order 80 on time reckoning, so the Saturday, Sunday will not be what? Will not be part. It also to have like the Monday, Tuesday, Wednesday, and then since clear days, it has to be Thursday before you can actually go for the court to hear it. So Saturdays, Sundays, and public holidays are excluded in the computation. If there's a short service, meaning that if you don't allow for clear days, that one is irregularity, is not a nullity. So you cannot say that because of that you should throw out the application. No. All that the court will do is to adjourn it, and probably either award costs. The cost may not even be awarded. The reason being that no litigant determines the date. is the court registry. So it's the court registry which have probably made what? Made a mistake. Or sometimes maybe like the bailiff, not also doing the service, if you like, in due time, so that we get the 4 credits as it were. I'm sure now you've all read Expert Target, haven't you? Who's here? Who has not yet read Expert Target? Okay, since you've all read it, Ophelia, Sean Metal, my own friend. Yes. What happened in this party? Audit relation to, yes.
There was it was about a fraud. So it was a bank. A bank actually brought an action against the applicants. And then I think 2 others to recover a debt owed. And then after the defendants had been served with the rates, they had entered appearance, and then the bank filed a motion for summary judgment against them. And then the motion was fixed for hearing, and for hearing on a certain date. And then the applicant was also served with it on a certain date. And then the trial courts with the first at the trial had at the trial high court, the respondent was granted the application, and then he entered, and then judgment was also entered in favor of the bank. And then the applicant's complaint was that the bank did not comply with the mandatory rule of the procedure, that there should be the 4 clear days between the date of service of the motion for the summary judgment and then the return dates. And then it's also contended that since the applicant was served on the days that was given earlier, the 4 clear days was, I think it's all on another day. And then they held that the contention was that the application should not have been moved on that particular date. But then the courts held that per order 81, the court intended to prevent the non-compliance with the rules of procedure, which resulted automatically in invalidating the proceedings. And then also it's held that what order 81 wanted to cover was the irregularities. And then that is yes, I wanted to clear the irregularities. And then the main principle from the case was that if there is an authority in the jurisdiction for the proposition that when the proceedings were taken by the plaintiff in the absence of the defendants, there should be strict compliance with the rules of procedure. And that it has also been held that if there is non-compliance with the mandatory rule of in the default of procedure, then such compliance cannot be waived. A judgment should be taken for such. A judgment taken for such non-compliance was therefore void.
Right. I thank you, Prophet. Co-prefect. I think it's fair to give you 1. Okay. Yeah, so once the defendant respondent has been served with the application, the defendant respondent in terms of order 14 rule 3 will need to show cause. So now we have a change. The procedural burden now shifts to the defendant. The defendant will now need to show cause why judgment should not be entered. And this is a very important step required of the defendant. Otherwise, a summary judgment will be entered against him. What does it mean to show cause? As we have under the 14 rule 3. Because that under 14 rule 3 says that 3.1, a defendant may show cause against the application by affidavit or otherwise to the satisfaction of the court. Or otherwise, and somebody asks a question in terms of the 14 rule 5 and rule 5.2. It was wondering, how could the court grant the stay of the execution of a summary judgment in view of a counterclaim, which may have to be dealt with, particularly so when a statement of defense has not been filed. And we have to bring our mind to the 14 rule 3. If you look at rule 3, that the defendant may show cause against application by affidavit or otherwise to the satisfaction of what? The court. So, or otherwise, it could be statement of defense and counterclaim which have been filed, be if it is outside time or within time, as the case may be. But we explained that further. So the affidavit or whatever permissible means that to be used must show existence of a tribal issues of facts or law, or some other compelling reason why the matter ought to proceed to trial. Mind you, at this stage, the defendant does not bear the burden of proving defense. It's not about proving that I have an iron cast or ironclad defense to the claim necessarily. No. All that is required of the defendant is to demonstrate bona fide, arguable defense recognized by law. So it's not concerned about the likelihood of the success of the defense, no. But is there tribal issues? That is what is important. And for that matter, a defendant may ultimately fail at the trial, and yet will be entitled to defend a summary judgment application. The court may say that yes, we will not grant summary judgment because we think that your defense suggests some tribal issues. But the fact that the court is saying that does not mean that when we do the plenary or the full trial, you are necessarily going to succeed your defense with the claim. So let's note that. So look at the case of Bronya against Asafo. Bronya, that's the Christmas in tree. Bronya against Asafo. The second, 1980 JLR 384. And the court indicated that the defendant must do more than mere denial. So if, for example, all that you are saying is that I deny all that the plaintiff has said, or just I deny this, I deny that, I deny that. If it's a bare denial, or simply saying that I do not owe the plaintiff, that is not enough. You must particularize your denial, in a sense. Set out some factual or legal basis upon which you are challenging the plaintiff, or you are contesting the plaintiff's claim, as it were. And for that matter, to show cause, the defendant must set out the particulars, engage with the plaintiff's claim, and identify issue that requires adjudication. That is showing cause. So you yourself, whatever you say your response is, what are they? And then 2, confront the plaintiff's claim head on, and then show to the court that there are questions which need to be investigated And that cannot be done unless evidence is taken in a full trial. So it is not right for judgment to be entered. So if you look at the again Gasub and Dizengoff, the point we made that what is required of the defendant once the plaintiff has made the prima facie entitlement to judgment in application is to make out a case for leave to defend. And this will be done in the following way. In the affidavit, the defendant can raise an issue of interpretation. So like if you are a smart practitioner and you're representing a defendant who has been served with the summary judgment, you have to open up your mind and based on whatever the plaintiff is talking about, if you can raise some technical legal interpretation or whatever, that is something which will require trial, isn't it? Or you dispute a material fact upon which the defendant is saying. For example, if it's about, maybe the plaintiff is talking about the fact that there's a certain contract, and you are saying that, well, you are setting up something which actually denies the existence of a valid contract between you. That is a triable issue. Yes.
In opposition, in this sense, it's not enough.
Affidavit in opposition is enough. Filing affidavit in opposition is enough. But what you put in affidavit in opposition, the things that you say, which is important. And you may do it one of two ways. You may say everything which you have, for example, set up in your statement of defense as part of your affidavit in opposition to the application for summary or judgment. Or you may just react to the affidavit in support, which he has done. And as part of it, as part of your affidavit in opposition, you also allude to a proposed statement of defense. And the proposed statement of defense will be one of two ways. If you are still within time for filing defense, it's not proposed. Just do your normal defense. You do it properly. And then you exhibit it. But if you are out of time, let's assume that the time for filing invented up to the time for even defense has elapsed. But then there's application for summary judgment. You can still do signal defense or propose signal defense and exhibit it to the affidavit in opposition. So when we say tribal issue, what does it mean? We'll be using the phrase tribal issue. A tribal issue exists where, assuming the truth of the defendant's allegation, the plaintiff's claim might fail in whole or in part. So that is what we mean by tribal issue. That is to say that if we assume, we give benefit of the doubt to the plaintiff's allegation, we assume that the defendant's allegation, we assume that what the defendant is saying in his defense, assuming they are true, either the totality of the plaintiff claim will fail, or part of it will do what? Will fail. If that is the case, then we have a tribal issue, which will warrant full trial rather than summary judgment. And the test is low, it's not the high test. So it's very easy to resist a summary judgment application. And that is why summary judgment will be granted really in deserving cases, because the test for resisting is very low. To raise a tribal issue is not that difficult. It's not whether the defense is strong, but whether it is legally cognizable. Whether the law, is it a kind of defense the law will tolerate? Yes, somebody wanted to intervene, yes.
Yeah, are we dealing with facts or not?
Both. Because the defense could be law, defense could be what? Could be fact. Because you have a mixed fact and law. Sometimes the defense may be law, but it cannot be dealt with properly unless certain evidence has been taken before we can even use that, as it were. So if you look at the case of the Prestige Limited, FEM's International Limited number 2, the Court of Appeal made the point that it may be that you will not be able to prove it at the trial. That is not the question. So it's not really the point that the defendant will not be able to prove what he's saying at the trial. What he's saying at the summary judgment, we assume what the defendant is saying is true, and it may not be true, but we are assuming it's true. If it is true, will it affect the claim of the plaintiff? If it will, then we need to go to trial. So what must the court do at this stage? I mean, the court is not supposed to do much. This is not the time for the court to test credibility as to whether somebody will believe or not to believe. No. It's not time to resolve conflict in the affidavit evidence. And then it is also not time to say that I prefer the version of the plaintiff account to that of the defendant. That is not required at this stage. So maybe let's give just a 1 or 2 example of this raising tribal issues. For example, if the defendant has its affidavit in opposition or the defense, in terms of showing cause why summary judgment should not be granted, it will be sufficient, for example, talk about non-delivery or defective performance, even a death of claim. Like the example that I gave, the person said that yes, we deliver certain things for you, having paid. If the defendant can say that they were not delivered, that will raise a question mark. It means we need to take evidence to find out whether there was a delivery or there was no delivery, isn't it? Or if there's some defect in the performance, then we need to also try that. Again, set off for counterclaim. Maybe sometimes the quantum of what the plaintiff is asking is contested. The plaintiff is asking for 500,000, and you say that yes, there's a certain default of my part, but certainly not up to the quantum that you are talking about. It's not 500,000. I've also not told you the exact amount, so you cannot say that I've made some admission. What have I admitted? I've admitted that I owe you, but I've not admitted any quantum, isn't it? And then we need to do some kind of try to establish that. There may also be dispute over interpretation of a contract or document. So when we say the interpretation, it's not only about law. We have terms of contract, isn't it? You can set up, yes, the plaintiff has pleaded that there's a contract between us. That is true, but it was never part of the terms of the contract that this and this was supposed to be done. So here, you are contesting the interpretation of what? Of the contract, isn't it? And that is an issue which will have to be tried. Or sometimes you may have a statutory defense like maybe a limitation or illegality. And here, if you have a limitation or illegality, there are certain factual predicates or premises which will need to be established first before we find out whether the illegality, for example, defense will hold or the limitation defense will hold. And all this will require what? Require some evidence which we need to warrant a trial instead of rushing to summary judgment. Now, if you look at order 14, rule 3(1), it talks about some other reason, that is, or otherwise to the satisfaction of what? Of the court. So, order 14, rule 3 recognizes that not all reason for refusing summary judgment can be reduced neatly into triable issues. It's not only where you have triable issues before we can say that there's no summary judgment. There are some other situations where you may not be able to reduce it into triable issues, and yet it will be a legitimate basis for not allowing summary judgment at that stage. So that is what we mean by the some other reason, or as order 14 rule 3(1) says, or otherwise the satisfaction of what? Of the court. So such reasons will include, for example, the need for cross-examination to resolve disputed facts. The defendant may say that, yes, they may, due to this and this and this and that, I need to cross-examine, maybe like the deponent and so on. Or such other reason will include necessity for discovery of documents in the plaintiff's possession. The plaintiff in the application will have exhibited certain documents, but he picked and chose the ones that you want to exhibit, isn't it? But there may be some other more documents which he has not actually exhibited. And you, the defendant, as part of discovery and interrogatories and so on, may want to push the plaintiff to bring all those things out. And then when they are brought out, you are convinced that it's going to undermine the case of the plaintiff, but it's going to reduce whatever claim that he is making. And for that matter, there may be necessity for discovery of documents in the plaintiff's possession, for which reason summary judgment should not be what? Allowed. Or the other reasons may include involvement of third parties whose evidence is material. The defendant might have set up a response in which certain third parties may have to come in, and the evidence is very material to what the plaintiff is trying to claim. Or it may have the presence of mixed questions of law and facts, which is not suitable for summary disposal. The defendant may say that there are certain matters which are not purely factual and they are not purely law. It's a combination of the two. And we cannot really resolve them just at this stage. We need to go into a full-scale trial before we be in a position to resolve them. So as you can see, the court really has a significant discretion when it comes to summary judgment. So what will happen if the defendant fails to show cause in terms of the points that we have considered? What will happen? So where the defendant fails to particularize defense or raise legally recognized issue or demonstrate any reason requiring trial as we've explained, the court is entitled to enter summary judgment. Then the court will enter summary judgment. Nothing will stand in the way of the court. Again, where the defense is evasive, the defense is contradictory, the defense is speculative, or is merely argumentative, it will not suffice as showing cause to prevent entry of summary judgment. The court will go ahead and enter summary judgment. Because the point about summary judgment is actually to eliminate such, quote unquote, sham or useless defenses, which are not defenses. Maybe let's look at an example of how to draft affidavit to show cause Now, if you look at the plaintiff applicant, let's look at the defendant what? Respondent. So let's say that if you are the defendant respondent, how will you draft affidavit to show cause why summary judgment should not be granted? So it's affidavit in opposition, of course. So all the features of affidavit, the court, the name of the court, the place, the year, and then the suit number, the title of the case, the parties will have to show. So in the High Court of Justice, let's say Commercial Division Accra, they have a suit number so and so and so between ABC Trading Limited and SYZ Enterprise Limited. Then you have the affidavit to show cause against summary judgment. You can simply say affidavit in opposition. It can simply be affidavit in what? Opposition to application for summary judgment. That is fine. They can have I, Michael Boateng of Accra, operations manager, being a director of the defendant company, do hereby make oath and say as follows. 1, that I'm the director of the defendant company, and by virtue of my position, I am conversant with the facts of this case and competent to depose to this affidavit. 2, that I have read the plaintiff's motion on notice for summary judgment and affidavit filed in support thereof. And I deny that the defendant has no defense to the plaintiff's claim. So look at it. The significant statement which we talk about, that the plaintiff is supposed to say that the defendant has no defense to what? To the claim, isn't it? So when you are the defendant, you're also doing affidavit opposition. It's one of the important things you should also need to confront and say that it is not true that I have no defense what? To the claim. Or I deny that the defendant has no defense to the plaintiff's claim. 3, that the plaintiff's claim is founded on an alleged supply of industrial equipment said to have been delivered between January and February 2024. 4, that the defendant dispute full delivery of the said equipment, and in particular states that a substantial portion of the machinery invoiced by the plaintiff was never delivered to the defendant. So here, look at the kind of defense he's trying to raise as part of the affidavit in opposition to force the court in not granting summary what? Judgment. 5, that the defendant immediately notify the plaintiff of the non-delivery and correspondence exchange between the parties, evidencing that this dispute will be relied upon at the trial of this action. So here, the defendant has not even exhibited the correspondence. Look at it. That the defendant immediately notified the plaintiff of the non-delivery and correspondence exchange between the parties, evidencing that this dispute will be relied upon at the trial of this action. The defendant has deposed to this. He will not exhibit those correspondence, but he is signaling that during the trial, we will rely upon them. So already trying to force the case to go into what? The trial rather than just allowing the summary judgment. 6, that the defendant further said that some of the equipment allegedly delivered was defective and unfit for the purpose for which it was contracted, resulting in operational losses to the defendant. 7, that the defendant has a bona fide claim of set-off and no counter-claim arising from the plaintiff's failure to deliver the full consignment and from the defects in the items supplied. 8, that the issues of delivery, quality, and set-off are matters of fact which require oral evidence, cross-examination, and documentary scrutiny and cannot fairly resolve on affidavit evidence alone. 9, that if the defendant is able to prove the matter deposed to hearing at the trial, the plaintiff claim will fail in whole or in part. 10, that the defendant has therefore raised triable issues of facts and law which entitle you to defend this action. 9, that are deposed to this affidavit to show cause why summary judgment should not be entered against the defendant. So if you have this, you notice that it will be difficult for the court to just ignore and allow the plaintiff to have what? summary judgment. And if you look at the affidavit we just went through the example, it's good and it's likely to succeed because it's able to show cause, isn't it? It goes beyond a bare denial. I didn't just say that I deny. But as you can see, it gave some information about its responses to the plaintiff claims. So it did not just say that I do not owe. It gave particulars that there was no delivery, isn't it? Defective performance. And there is also, it even has a set off. And this is very important. So when we are drafting such affidavit, so the point we should note is that when we are drafting affidavit for the defendant, a good affidavit to show cause must do the following: 1, identifies the issue. 2, explain why it matters. And demonstrate why trial is what is necessary. So if you are for the defendant and you are drafting affidavit to proceed to summary judgment, you must always have this kind of things on your mind. Now, when the court is hearing this application, in terms of the 14-5, what can the court do? What are the powers of the court? We have noted that first and foremost, the court may enter judgment for the plaintiff, either in respect of the whole claim or in respect of part of the claim. So if, for example, the court is satisfied that regarding portion of the claim, the defendant has not been able to raise any triable issue of fact or law, and for that matter, there's no other reason why the matter should proceed to trial. The court will allow judgment to be entered in respect of that particular portion, as the case may be. So let's keep that in mind. The court can also grant unconditional leave to defend, where the court is satisfied that there's a bona fide triable issue, good triable issues, as we've seen. The court can give the defendant leave to defend the action, and for that matter, the summary judgment will not be granted as it were. Of course, it is also true that the court has the power to dismiss the application for summary judgment. And when and why would the court dismiss the application for summary judgment? Maybe where the defendant has shown cause by raising triable issue, as we have seen, or the application is procedurally defective. When we say procedurally defective, it may well be that the statement of claim itself, if we test it against Order 11 Rule 18, is not even problem-free, isn't it? For which reason the court cannot gloss over and allow summary judgment. Or it may well be that the action falls within the excluded categories and under 14 Rule 12. Under 14 Rule 12 has given some matters in respect of which cannot get summary judgment. For example, defamation, malicious prosecution, matrimonial proceedings, maritime, probate, breach of promise to do what? To marry. And then fraud, yes. I think in the UK, they have abolished this cause of action, breach of promise to marry.
Why?
If you look at the world in which we are living now, a lot of things have changed, isn't it? In the past, breach of promise to marry probably was very significant, but now, you look at the world has changed. Now, let's talk about summary judgment on counterclaim. No, but just before that, earlier on, there was a question about Order 14-5-2. And I want you to keep Order 14-5-2 in mind. Stay of execution. So when you talk about stay of execution, there are a number of instances in the rules where there will be stay of execution. So this is one of them, where in the summary judgment has been granted in respect of part of the claim. And maybe for the other parts, trial will have to be done. The court can grant stay of execution of the summary judgment granted in respect of that part, pending determination of the other part. Or where summary judgment has been granted in respect of the entire claim of the plaintiff, but then there's a pending counterclaim. The court may also decide to grant stay of what? Execution of the summary judgment in favor of the plaintiff, pending determination of the counterclaim as the case may be. So let's keep that in mind. Just as when we have had like the full trial, either pending instrumental payment, there could be a stay of execution, or pending appeal, there could be stay of what? Execution, as the case may be. Summary judgment on counterclaim. We have seen that a counterclaim is a case within a case. It's a cause of action within a suit, isn't it? So it's an independent cause of action, or independent case, as it were. And that is why if the plaintiff claim is even dismissed, the counterclaim will still survive, as the case may be. And for that matter, all the things you have said about summary judgment in respect to the plaintiff claim, mutatis mutandis are applicable to what? To counterclaim as well. And that is what Order 14-10 tells us. Order 14-10, summary judgment on counterclaim, where in an action, the plaintiff is served with a counterclaim, the defendant may at any time after serving the counterclaim, on the ground that the plaintiff has no defense to a claim made in the counterclaim or to a particular part of such a claim, apply to the court for judgment against the plaintiff on that claim or part of it. Then return sub-rule 2. Rules 2 to 9 shall apply to an application under this rule with the following modifications. A. Reference in the rules the plaintiff and defendant shall be construed as referring to defendant and plaintiff respectively. So all the things that you have said, they are all applicable to a counterclaim. So if the defendant, who is a plaintiff in respect to the counterclaim, is convinced by the merit of his case that for the counterclaim, the plaintiff, who is now the defendant to the counterclaim, has no defense or cannot have any triable issue being raised, he too can move the court for summary judgment. So let's keep that in mind. Now let's talk about setting aside summary judgment. Order 14-9. Setting aside summary judgment. So summary judgment, as you have seen, is final in character. That notwithstanding, we have limited circumstances in which a defendant affected by summary judgment may get it set aside. So if we look at Order 14-9, it says, a judgment given against a defendant who does not appear at the hearing of an application under this order may be set aside or varied by the court on such terms as it considers just upon an application brought within 14 days of the service on the defendant of the notice of the judgment, isn't it? I want us to, let's put our hand at that group. I want us to compare that with Order 36, the trial, where you go to Order 36, I think there's a similar, good, Order 36 rule 2. Order 36 governs full trial, like when you've done, not the summary judgment, but when you've done like the full trial. So Order 36 rule 2 says that, rule 2.2, let's start with, a judge may set aside the very on such terms as that judgment obtained against the party who fails to attend at the trial. Now 36 rule 2.2, an application under this rule shall be made within 14 days after the trial. So let's say that where you are having full or plenary trial, and then a party, for example, was absent, and then in terms of the 36 rule 1, the court, if the plaintiff is absent and the defendant has counterclaim, the court will dismiss the counterclaim and allow the plaintiff to prove his case. If the plaintiff is absent and the defendant is present and the defendant has counterclaim, the court will dismiss the plaintiff claim and allow the defendant to prove his counterclaim. So they are all judgment, as it were. And we are told that if you are so affected, then you have 14 days from that time to move to have it set aside. In the same vein, when it comes to summary judgment, as we have just seen, under Order 14 rule 9, where a summary judgment has been also entered, when in your absence, the court can be moved within 14 days for you to set the summary judgment aside against you. So let's keep that in mind. Yes.
The 14 days. At what time don't mind that.
No, when the notice of the summary judgment has been served on you. No, because let's say you're not in court. You've been served with the application for summary judgment. A return date is on it. But when the return date was due and the application was moved, you were absent. So the court was satisfied and granted the judgment against you. So the plaintiff will have to do what we call the entry of judgment. Entry of judgment in terms of the ruling the court gave and to be served on you. Because later on, when we're discussing execution of judgment, you notice that it is mandatory for entry of judgment to be filed and served before you can set in motion any of the execution mechanism or processes. So when the entry of judgment is served on you, you become aware that summary judgment has been entered what? Against me. Then from the day of being served, you have 14 days within which to bring application in court in terms of Order 14 rule 9 to have the summary judgment set aside. Yes.
The summary judgment, the defendant was missed.
Yeah.
And on the day of hearing, it fails to appear before the
Yes.
judgment was against and made against. And then he is allowed to come back again to say that all the time we have spent to do all of those who want to do set aside. Why would the law allow such? Or are there specific instances where the defendant take a case?
Yes. Good. So setting aside summary judgment entered in absence of the defendant is not for asking. It's not just you go and automatically to be set aside. You must give good reasons. And what are the good reasons which will let the court exercise discretion to set it aside? So the 14 days we are talking about apply only where the defendant was served, as we just explained. And 2, the defendant had notice of the proceedings but failed to attend. So let's assume that you remember Ghana Cables and Barclays Bank. Remember that case? Or Barclays Bank, Ghana Cables, remember that? Where failure to serve a process on the party. follow the natural justice what rule. And if any judgment or order have been made, then it will be a nullity. Remember that. And it cannot even be cured by order 81. Good. So, where the application for summary judgment was not served on you. So let's say that there's no proof of service. Or even if it was served on you, maybe there's some question mark about the propriety of what? Of the service. So later on, you go and conduct a search in the registry. You get all your answers. So in that case, the 14 days will not even apply to you. Because what has happened, and that is why we say that a court will be entitled as debito justicia to have the matter what? Set aside, because that's a nullity. That's a nullity. But where you were served regularly, so let's talk about condition for setting aside a regular summary judgment. So where you regularly been served, and there's a proper summary judgment given in your absence. Let's talk about that. The defendant must satisfy two cumulative requirements, somewhat analogous to default judgment, if you remember. So one, there should be a satisfactory explanation for failure to appear to oppose the application. So why did you fail to appear to oppose the application when you have actually won? You said. And two, the existence of a bona fide defense raising a tribal issue. So in the motion that you take to court, in terms of Order 14 Rule 9, to set aside a summary judgment entered in your absence, the affidavit must demonstrate these two things. Good explanation. Why, despite having been made aware that there was going to occasion for summary judgment, you are not there to oppose it. You're not there to oppose it, or you're not even there to file affidavit on what? Opposition. If you file affidavit in opposition, the court, you've assisted the court, because then the court cannot ignore the affidavit in opposition. It's part of the application before it. What is lacking is that your lawyer is not there to make the legal argument. But then if the affidavit is well crafted, the court will be in a position to make a determination as to whether tribal issue exists, for which reason summary judgment should not be granted. So that is fine. But it may well be that when you were served, you didn't also file any affidavit in what? In opposition. So whatever be the case, the affidavit that you are filing to set aside the summary judgment entered in your absence must explain, must give good reasons why you defaulted in not going to court or in failing to file the affidavit in what? In opposition. You must explain. And two, the affidavit must also show that you have some good faith, bona fide tribal issues. Because if you cannot show any bona fide tribal issue, then what is the point of setting aside? So all that you're saying is because I was not there, and summary judgment has been set aside. Then when they set aside, okay, what do you have to show to prevent them from giving summary judgment? You have nothing to show. So that is not it. So look at the case of the Trust Bank Limited against GK Appiah and Sons Limited. Trust Bank Limited against GK Appiah and Sons Limited. 2011 to Supreme Court Ghana Law Report 894. And then the court will remind us that the rules of procedure are there to facilitate justice, but must not be applied in a manner that encourages laxity or tactical delay. Now let's look at the other scenario for judgment entered without notice. So that one is void ab initio, as we have noted. If a summary judgment was entered without notice to the defendants, when the entry of judgment is served on the defendant and becomes aware for the first time that there's even something going through judgment entered against me, you quickly have to rush, go and conduct search to make sure that there is no information that has been served on you and so on. If there's information that has been served on you, and if it's a matter of truth, it was not served on you, that's also another case. It means that the judgment has been obtained fraudulently, isn't it? And you have to issue a fresh writ. You have the summary judgment, which was obtained fraudulently, to be set aside. And you have to go into the circumstances in which information was put before the court that you have been served, when, as a matter of fact, you have not been what? You have not been served, as it were. So where the judgments were entered without notice to you, which is void ab initio, in that case, there's no time limit, as it were. So the 14 days does not what? Does not apply. The 14 days does not apply because it is void, and the defendant is entitled to have such a judgment set aside as debito da seizure, that as a matter of right. So look at the old case of Takoradi Timbers Limited against Amua. Takoradi Timbers Limited against Amua. 1982-83, JLR 1140. And there, the court will hold that a judgment entered without notice violates the elementary rules of natural justice and is what? Is a nullity. And here, where the judgment was entered without notice to you, you don't need to show the things that you have to show. If the judgment was entered with notice to you, but that one is a regular summary judgment, but this one is irregular. So since it's irregular, the defendant does not need to show that he has a defense on the merits. No. You don't need to show that. But if it was a regularly obtained summary judgment, then if you are going to set aside order 14 rule 9, you need to show that you have a defense on the merits, isn't it? Now, how does this relate to order 81? How does this relate to order 81, order 14 rule? Now, how does it? It must be read with order 81, as we know, which governs the non-compliance. And as we know, order 81 provides that non-compliance with the rule does not automatically nullify proceedings unless it goes to jurisdiction or fundamental fairness, isn't it? As it were. So therefore, where summary judgment is entered after short service or with defective service like the one I was telling you, like somebody had just manipulated the system and get the bailiff to do proof of service, when as a matter of fact, you're not served and so on. Or in breach of mandatory notice requirements, the court must determine whether defect is a mere irregularity or what, or fundamental one, as it were, in which case a nullity. Now, what is different between setting aside summary judgment and also appealing? Are they the same? Can we appeal summary judgment? Can we appeal summary judgment? Why no? Yes. So we have application to set summary judgment, which we'll be discussing under order 14 rule 9. And order 14 rule 9, you've seen, is concerned primarily with absence from hearing or lack of notice, or maybe some kind of like a procedural injustice, as we've just explained. But we have appeal. You can appeal against summary judgments on merits. Now, a defendant who was present at the hearing of summary judgment was granted hearing in terms of having filed in opposition or having been heard through the lawyer and lost on the substance of the application cannot invoke order 14 rule 9. So if you lost, you cannot come under order 14 rule 9 to have it set aside. No. You have to appeal. you have to appeal, but not to have a set aside or the 14 rule now. So that's the point that we are trying to make. So I'll give you 3 minutes break. But there's a case I wanted to discuss with you, which is very instructive. And then we start third-party proceedings. We start third-party proceedings before we go. So procedure is a lot, and I want you to learn it, but that is why I take my time to expand things. But the 14, somebody used just 20 minutes to teach you the 14. But those areas which are important in practice, I think that students should be taught comprehensively so that they are ready to go. So let's look at the case of Sumala Sanunu. I have briefed it. I just wanted to discuss it as an illustration of summary judgment. Sumala Sanunu against Franklin Gado Salifu is a 2009. I took mine from the Danish law database. But as a decision of the Supreme Court, 22nd April 2009. I wonder what the title is. Sumala Sanunu. I've given the decision already. I said Sanunu and the Salifu, remember? Yes, I've given you at the beginning. Good. So, I just want us to talk through the case together. In that case, the appellant was a contractor, was awarded contract by Ghana Telecom. Being financially constrained, he approached the respondent to finance execution of the contract. A statutory declaration was executed, which indicated joint execution of the contracts between them. Upon completion, Ghana Telecom paid 137 million old Ghana cedis, I hope, not the new Ghana cedis. The respondent claimed he solely financed the project with 107 some plus million. The appellant disputed this and contended the amount spent was about 95 million, and that he had already paid 94 million to the respondent, and that the agreement was between the respondent and Frank Sally Enterprise Limited, not him personally. So there was an application for summary judgment. An application for summary judgment, the respondent annexed a document titled contract, described by the court, the trial court, as a promissory note, which allegedly admitted liability. Now the defendant raised issues, including dispute as to the actual amount invested, duress in executing the promissory note, that the duress was put upon him, and that is a wrong part which has been sued. Something like the Mokwe Nkuma, remember Mokwe Nkuma argument, that the company is distinct from the managing director. So the central issue, whether on the pleadings and affidavit before the trial court, the defendant had raised triable issues sufficient to defeat an application for summary judgment under the 14 reward. One. So the court, speaking through, I think that is the Bafo Boni, actually canvass or review the law as we'll be discussing the authorities. And the court, speaking through Bafo Boni, as he then was, identify several tribal issues which were improperly ignored by the lower courts. Because the lower court has gone ahead to grant summary judgment. And then the affected party decided to appeal. And that is why we said that you can appeal summary judgment. So, according to the Supreme Court, there was a material factual dispute regarding how much the respondent contributed. One was talking about 107 million plus, another was talking about 95 million. So this required evidence, isn't it? and you need to go through trial to establish it. And again, the alleged promissory note was not pleaded in the statement of claim, but was introduced at the summary judgment stage through affidavit. And the court was of the view that it was improper. It's a material fact which should be what? Should be pleaded. It should be pleaded. And we said that affidavit cannot cure defect in what? Statement of claim. Do you remember that? So you're trying to use the affidavit to cure a defect because it's a material thing you need to prove which you have been pleaded. And then the defendant was not given proper notice. The defendant was not given proper notice. So another point which they identified was that the defendant alleged that the document was procured under duress. And if it's under duress, it becomes a bit similar to allegation of fraud and so on, isn't it? And under 14 rule 12, it's excluded, isn't it? Good. So the Supreme Court ultimately held that the defendant had raised rare tribal issues, and lower courts were duly influenced by the documentary evidence. So the summary judgment was inappropriate, and it allowed the appeal and remitted the case back to the trial court for the trial on the merits rather than summary judgment. Okay, having discussed this with you as friends, you go and read the other cases, isn't it? Good. So I'll give you is 737. So when it's 7:40. So get up, don't go out. Just move. Right.